This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hebner, and on behalf of Judge Bennett and Judge Davis, we welcome both counsel to this oral argument, which we are live streaming to fulfill our obligation to maintain open courts. We will conduct the hearing in the same fashion as if we were all together in the courtroom. Each of you has 15 minutes to present your argument, and the appellant has reserved some time for rebuttal. Unless there are any announcements, I'll ask Mr. Hebner to call the case.
AB Normal, LLC versus State of Tennessee.
All right, appellant, we'll hear from you.
Good morning, Your Honors, and thank you. I'd like to begin today by I'm going to recite some facts surrounding our case. And at any time, if you have any questions, please feel free to interject. It's not going to throw me off. It's not going to do me any disharm.
Rest assured, we'll do that.
So the gravamen of this case, it deals with a state easement bridge. And this is 17 acres that sit just east of Nashville. This is Gainesboro, Tennessee. My client, Charles Cummings, and his family bought the property back in 2016, and they made the pilgrimage there and moved their family to this property to live off the land and to harvest cotton where they own a farmhouse. The farmhouse itself was built in 1917. When they bought the property, they immediately started remodeling and spent 2 years doing so. And the only access and ingress to this land is, like I said, a state easement bridge that comes off a state highway. It's surrounded on 3 sides by water. On the 4th side, it's abutted by a tree line and a fence that is their neighbor's property. So there is no other entrance to this land. When they bought the property in 2016, they did not know, or at least at the time, the bridge was not in such a bad condition. But progressively over the next 18 months, water would bottleneck between the 2 creeks there, and it progressively got worse. And they started noticing driftwood and things that would come up on the bridge. So in 2019, they got the state involved. They first contacted TDOT. They went through several channels first and were put in touch with TDOT. And in September of 2019, the first TDOT representative came out to their property. It's a lady by the name of Lisa Scantling. She came and walked the property with Mr. Cummings and assessed.
Are you suggesting that the flooding over the bridge is the state's fault?
We're suggesting that the bridge itself, the condition of the bridge, is owned and maintained by the state. So we are suggesting that the state's responsible for the bridge, and that's why state engineers came out to assess it on several occasions.
Well, I agree that the state is responsible for the bridge. I understand that argument, but is the state responsible for the flooding that has begun to come over the bridge?
And the short answer is yes. The short answer is yes. So the bridge itself was built in 1961 by the state. Now, originally on this piece of property, there sat a church and a fire department. Both of those had to move because in 1961, the state came in, rebuilt this bridge, and it actually redirected the flow of water. So yes, we are suggesting the state's responsible for the flow and for the bridge itself. Now,
Okay,
yes, Your Honor. In 2007, so in September 2017, the first TDOT representative comes out, walks the property, and agrees. She says, the bridge is desperate need of repair or replacement. She said, let me go to my superiors and come back to you with an answer. So that in October of 2019, Josh Neal, another representative from TDOT, comes back with Lisa Scantling, and together they walk the property again. They agree. It's in worse shape. It needs to be replaced or repaired. And he agrees, I'm going to go to my superior. We're going to find out. These sort of things take time. You have to allot money, and we don't know what kind of engineering is needed. We need to speak with one of our engineers. That's in October 2019. Then in December 2019, there is a phone call, and all these are recorded, by the way. All these conversations are recorded, and we have the recordings. In December 2019, they have a phone call where he says, can you send me pictures and video of the bridge so that I can pass it along to one of our engineers and we can actually get somebody involved? He does that. Mr. Cummings takes pictures. He sends videos. He sends everything requested of him. That is December 2019. On February 6, 2020, lightning strikes their home. It struck in the corner of their house right next to the downstairs bathroom. Mr. Cummings, the way he describes it, it's like a cannon going off in the house. He immediately knew this was at 6 p.m. So the kids are still awake. They're getting ready. They're winding down. He hears this lightning strike and immediately, now he's a disabled veteran. So he's experienced in war. That's what he likened it to. He said it was like a cannon going off in the house. Sprints downstairs, sees, and it's not a fully ablaze. He sees that there's fire, and there's rain obviously going on. There's this thunderstorm. So he calls 911. The fire truck comes out and he meets him at the state highway and he's waving a flashlight. He already knew it was going to be an issue. He's known the bridge was a problem. That's why he's had all these conversations with the state over the past several months. So he flags down the fire truck, and the first engine starts making its way over the bridge. And by the way, this is all recorded. He recorded the fire truck trying to make its way across. Fire truck starts across the bridge, and quickly the fire chief pulls back and says, I cannot afford to lose this thing. I mean, the fire trucks are $500,000. I can't risk this. So I have to pull back, and I need you and your family to pull back. He would not let them go inside to retrieve anything. And they stood there and watched their house burn for the next several hours and helpless. There's nothing they can do. They can't go near it. It's too dangerous. So the next day he calls TDOT. Bo Haskins is the engineer. And his response to all this is, well, I don't know to tell you about the house, but we can try and put some money together for the bridge. As it stands today, almost 2 years have gone by. The land itself is uninhabitable. They're still paying ad valorem and property taxes on it. They can't live there. They can't live off the land. I mean, these are blue collar, salt of the earth people. This was their livelihood. They can't harvest cotton. So their entire family's been displaced. Mr. Cummings and his wife and 2 boys are living in Georgia. They're having to stay with friends and family. And then his mother, their grandmother, had to go back to North Carolina. They don't have any other resources. This is it. This is their last line of relief. And when they filed their claim, the state filed its motion to dismiss. And in its motion to dismiss, and to Mr. Evans' credit, they do cite cases where their premise and their position is the state's not responsible for lightning. Lightning's unforeseen. It's an act of God. And we get that. But the cases that are cited aren't congruent to this case. Those are golf cases. And with all due respect, those are from the late 70s, where a string of these cases and their progeny deal with gentlemen who are going out on a golf course on an afternoon when they know they shouldn't be out there. It's raining, it's thundering, and they're being struck by lightning and killed. And then their spouses are suing the state because these are municipally owned golf courses. And they're saying, oh, there should have been some warning. But that's not congruent here. That's not the same set of facts here.
But Mr. Gallagher, I don't think the Hames case really turned on the fact that the decedent chose to go out and be in a lightning storm on the golf course. I mean, I think the issue was, and the issue that was raised by his representatives was, you guys should have built shelters. You should have done something to allow protection in a lightning storm. And so is that not akin to this situation where you're saying you guys should have fixed the bridge because you should have known that if lightning struck our house and a fire occurred, then our house is going to burn down because we can't get over? I mean, how is the Hames case actually distinguishable?
Well, I would say that we're dealing with fire, not lightning. And last time I checked, every city has a fire department. We know it's an issue. Now, lightning wasn't what he called the state for. He was afraid one of his boys would fall, have an accident, break their leg. That was the real issue. That's what he's concerned about, because they farm. So his thought process is, I work with my hands and feet. If I get hurt, no one's gonna be able to get to me. And my boys aren't gonna be able to help me. They're too small. Lightning is unforeseeable, but fire is preventable. And I would say the big takeaway from that case, and the distinguishing characteristic, is 3 times the state came out, acknowledged, and knew in several months leading up to it, all we have to do is take some sort of action. And to date, it's not been repaired. And even if they wanted to sell the land, they can't. It's tied up in litigation, and it's completely unusable.
Well, doesn't repair of a bridge, that's not something that the state can ordinarily do instantly. They have a budget that's already set and projects already in place, and they have to, as I think you alluded to, gather money and the state was in the process of gathering facts and money. Are you just saying the state should have been faster, or what?
Well, I do think in 6 months leading up to it, they could have taken some action and at least steps to alleviate it, because we do know that the road nearby their home has failed, and they've come out and repaired it in time. They do it the same weekend. And so they were familiar with Lisa Scantling. She's been around their property. They knew who she was already because they had seen her out doing road work with TDOT in the highway that abuts their property. They've had issues before with that road, not just them, their neighbors, obviously, with that state highway. So they knew Miss Scantling, and that's really how they came in contact with her. Was they asked her, who do we contact? Who do we need to speak to about our bridge? Because this is an issue. And I will say this, with my time running down, this is it. I mean, they're limited their amount of recovery. $300,000 is the maximum they can recover. And now with building costs triple that, they're not gonna be able to rebuild for that. It's not feasible. I mean, lumber's gone up 4 times what it was before COVID, just the cost of repairs, but they don't have any other form of relief. So their entire livelihood is predicated upon the court's decision today. I'm not saying that the state should have or could have acted sooner, but it could have taken steps to alleviate it at least. And at least after the third conversation with them, if we were to start over and just sum arguendo, just for the sake of argument, if we started from ground zero and Mr. Cummings came to the state and said, what do I need to do? I mean, my bridge is failing. I can't get on my property. I'm concerned. We would send him through the same avenue. He went through all the proper channels. He did everything that he was supposed to do. And if the court does set aside the order of dismissal, it's not opening the floodgates. This isn't bad public policy. And if you have any question about that, look no further than the fact that we're citing cases from 1800 in New York, right? We're citing cases from Chattanooga in 1917. And even those facts, those are people who called for emergency services and there were unforeseen circumstances. There was road work going on. There were obstacles. There were delays that prevented them from getting there on time. That isn't this. They had 3 reasonable conversations with the state and asked them effusively, please help us. Please come out, do whatever it needs to do. If it's just making a minor repair for now, if it's putting a Band-Aid on a bullet hole, but do something to stop the bleeding. It just progressively gotten worse and it's only gotten worse since. And to date, they don't have any other form of recourse. This is it. This is their last source of relief. And unless there are any other questions, I'll concede my time to Mr. Evans.
Thank you, Mr. Gallagher. General Evans.
Thank you, Your Honors. May it please, may it please the court?
Yes.
My name is Michael Evans on behalf of the state of Tennessee. Your Honors, we ask that this court affirm the Claims Commission dismissal on 2 grounds. First, that the state can't be held liable for damages resulting from lightning. And second, because the alleged negligence here is simply too attenuated. Put simply, the chain of causation in this case is broken at 2 different links. No act or omission of a state employee directly caused the damages that we're here about. Rather, the damages were caused by fire, which was itself caused by a natural occurrence, a lightning bolt. The state maintains that the Claims Commission correctly held that lightning started a fire, which was itself the proximate cause of the claimant's injuries, rather than anything the state did or did not do. The first issue is that the state can't be held liable for damages resulting from lightning. This was the rule laid out in Hames v. State and in Davis v. Country Club. In Hames, the court put it that it's simply not reasonable to require a person to anticipate when and where lightning will strike. The second separate issue is the more broader rule that the state can't be held liable for damages here because the negligence that is being alleged is too attenuated. In Hames, the court laid out the rule. It was taken directly from Ward v. University of the South, but it's in the corpus juris. It's a well-established rule that when you have 2 causes, one being the direct cause and one furnishing the condition by which the direct cause ultimately causes the damage, only the first, only the direct cause remains the proximate cause. Here, and again, we're on a Rule 12 motion, so we're accepting as true every factual allegation in the initial pleading documents. And accepting everything as true, at most what can be said here is that the state's alleged negligence can be accused of furnishing the conditions by which the damage was ultimately made possible. But the fire and the lightning, here the proximate cause, they remain the direct cause and the proximate cause, breaking the chain of causation and relieving the liability of the actions of the state. On these general issues of foreseeability and the allegations of actual notice, it's important to notice what it was reiterated in Hames, but it was laid down in Davis, the point that bare possibility is simply not sufficient. Events that are too remote to require reasonable vision need not be anticipated. Here, again, taking everything as true, assuming all the factual allegations in the complaint, at best are general statements about the possibility that they might need emergency services. That is far removed from saying it is probable that lightning would strike and start a fire on the same night that you had sufficiently excessive rain to flood and cover this bridge.
Mr. Evans, what if the injury were different? What if, for example, the plaintiff had a health emergency, like he was suffering from a heart attack, and we have the same situation? It's the middle of a storm. He can't get emergency care and he dies. Is your argument the same?
Yes, Your Honor, it would be the same. And I think the reason being that because the operative direct cause here is an act of God or a natural occurrence, the unpredictability of that natural occurrence is at the core. The attenuation would still stand because if the issue is this bridge, then there's sort of a zone of danger around the bridge. And as long as the plaintiff is outside of that zone of danger, that duty and that foreseeability is held not to rise. But I think Your Honor does point out something I did want to point to. In dealing with this distinction between the possible foreseeable and the probable foreseeable, it is worth knowing, as Mr. Gallagher just pointed out, that even the plaintiff themselves were not immediately concerned with the damage that actually happened. So in order to oppose liability here, you would need to hold the defendant liable, hold that the defendant foresaw that something was foreseeable to the defendant that was actually different than what the plaintiff themselves foresaw as the concern. Namely, as you put it, you get hurt on the farming equipment, emergency services can't get access to it. And then that's, of course, where we brought in all the outside cases to supplement. Though, again, the state still maintains these cases are completely decidable just on Hames and Davis themselves. I did just want to just keep on that one point. The court in Hames did distinguish between those times when a natural occurrence expunges liability and those times when a person is still liable for it. And it's exactly what Your Honor is pointing out, that it has to do with whether the harm foreseen was the same as the harm that was ultimately caused by the natural occurrence. And here they're completely different. The harm foreseen, the harm that was concerned was the farm injury, inaccessibility, that. But here, the harm that ultimately occurred was the lightning that started a fire. Just the last couple of things. I did want to touch one thing here. As it's laid out, again, we're ceding all the factual allegations in the complaint. So I'm going to cabin myself just to the allegations in the complaint, accepting the allegations as alleged. But even on that, I think it's worth noting that it wouldn't be true to say that TDOT did nothing. As Mr. Gallagher just laid out, again, there was an active conversation going on. And we can actually go a little bit further to that. If we accept, of course, normally for Rule 12 motions, we're looking just at the four corners of the complaint itself. But as Your Honors know, with the Claims Commission, there's the initial pleading document of the notice of claim, and then later on, there's the complaint, the formal complaint that's filed. If we include in the Rule 12 factual allegations that are accepted, we additionally have the fact that before all this happened, in the notice of claim in page 4 of the record, it is pointed out that TDOT did tell the claimant that the bridge was their responsibility. Now, again, all that we're accepting, accepting the facts as alleged, we're only accepting that that statement was made, so we can still accept everything else under Rule 12. But that is one fact that's worth mentioning. And with that, I mean, that's the core of the state's position. I think as a final note, it's worth noting, we've touched a little bit on Hames finally, but really Davis v. Country Club has yet to be distinguished throughout any of the briefing. On this issue of comparative fault, one thing that gets lost in the distinction between Hames and Davis, since they are so similar, is the fact that while it's true that in Hames there was this comparative fault issue of the claim to stay out in the rain, that's actually not true in Davis. In Davis, they went and got to a weather shelter. They went to a weather shelter, they sought shelter, and it was the non-lightning proof ability of the shelter that was at issue. So if you take Davis, that comparative fault issue is completely removed at all. But then again, we still have these outside state cases that in the briefing on the motion to dismiss, in the oral argument, in the briefing, in the appellate, and in the reply brief, they're still left largely undealt with. The Hazel case and the Shelley case, both of which were expressly cited by the Claims Commission. With that, that concludes the state's argument, unless your honors have any other questions or points that your honors feel need clarification or expunge.
All right. Thank you, General Davis. Unless there are any questions from the panel, we'll turn to Mr. Gallagher.
Thank you, Your Honor. And may it please the court, two issues I do want to bring up that were not brought up before. One, we have a report prepared by the fire chief that does state emphatically they arrived in time to save the home. They could have prevented the total loss of their home. They arrived with plenty of ample time to put that fire out. So this was preventable. This would have prevented the total loss of their home and their abutting property, because remember, it did burn a lot of their cotton as well. They could have put that fire out and saved the contents of their home, and they lost everything. Again, this is a disabled veteran. He lost all of his awards, all of his regalia, all of his keepsakes. They can't replace any of those things. And second, the more important issue I want to raise is, and it's brought up in our complaint, and it's in the record, is the fact that in the city of Gainesboro, there is a municipal code that requires citizens and landowners to maintain and allow access to emergency services and fire department. If roles were reversed, if this were a privately owned bridge and the state were trying to get access to its property, and 3 times they warned the landowner, hey, your bridge is out. We need to get access to this. This is our fire department, or this is our church, or this is a state-owned piece of property. And they didn't allow that, or the same set of circumstances went down. You'd better believe that they would be holding my clients accountable, and they could be charged with criminal negligence too. If somebody were killed or seriously hurt, they would be on the hook and they would definitely be liable. They could not escape liability here. It's not fair to them that the state can do the same thing under the same set of circumstances, yet they are statutorily required to provide the same access and allow access to emergency services. The foreseeability issue is there. The state was on notice. They were on actual notice. They came and laid eyes on it. They specifically inspected it, and they know that it's their bridge, and they accept that. And we haven't even been able to get to the discovery phase because this is a motion 12. There's a Rule 12 motion that dismissed our case from the outset. They have not had their day in court. My clients to this day have never been heard. No courts heard them. The only hearing we had was telephonic, and that's due to COVID, but no one's even seen or heard from them. And they're going to lose everything that they saved their entire life for because of a loophole, a workaround, when they are personally responsible for the same obligation. The city of Gainesboro requires the same thing of them. And that's all I have, Your Honors, unless you have any more questions.
All right, hearing no further questions, thank you both for your arguments. We will take this matter under advisement. Mr. Hibner.
This honorable court is now in recess until 11 a.m.
Counsel, you're free to exit the Zoom meeting.
Thank you, Your Honor.